Rules of Court, Rule 60, Replevin. Section 1. Application. A party praying for the recovery of possession of personal property may, at the commencement of the action or at any time before answer, apply for an order for the delivery of such property to him in the manner herein provided. Section 2. Affidavit and bond. The applicant must show by his own affidavit or that of some other person who personally knows the facts, A, that the applicant is the owner of the property claim, particularly describing it, or is entitled to the possession thereof. B. That the property is wrongfully detained by the adverse party, alleging the cause of detention thereof according to the best of his knowledge, information, and belief. C. That the property has not been distrained or taken for a tax assessment or a fine pursuant to law, or seized under a writ of execution or preliminary attachment, or otherwise placed under custodial legis, or if so, seized that is exempt from such seizure or custody. And D. The actual market value of the property. The applicant must also give a bond executed to the adverse party in double the value of the property as stated in the affidavit aforementioned. For the return of the property to the adverse party, if such return be adjudged, or for the payment to the adverse party of such sum as he may recover from the applicant in the action. Section 3. Order. Upon the filing of such affidavit and approval of the bond, the court shall issue an order and the corresponding writ of replevin, describing the personal property alleged to be wrongfully detained and requiring the sheriff forthwith to take such property into his custody. Section 4. Duty of the Sheriff. Upon receiving such order, the sheriff must serve a copy thereof on the adverse party, together with a copy of the application, affidavit, and bond, and must forthwith take the property, if it be in possession of the adverse party or his agent, and retain it in his custody. If the property or any part thereof be concealed in a building or enclosure, the sheriff must demand its delivery. The sheriff must demand its delivery, and if it be not delivered, he must cause the building or enclosure to be broken upon okay. If it's not delivered, he must cause the building or enclosure to be broken open and take the property into his possession. After the sheriff has taken possession of the property as herein provided, he must keep it in a secure place and shall be responsible for its delivery to the party entitled thereto upon receiving his fees and necessary expenses for taking and keeping the same. Section 5. Return of property. If the adverse party objects to the sufficiency of the applicant's bond or of the surety or sureties thereon, he cannot immediately require the return of the property. But if he does not so object, he may at any time before the delivery of the property to the applicant require the return thereof by filing with the court where the action is pending a bond executed to the applicant in double the value of the property as stated in the applicant's affidavit for the delivery thereof to the applicant. In such delivery be adjudged, and for the payment of such sum to him as may be recovered against the adverse party, and by serving a copy of such bond on the applicant. Section 6. Disposition of property by sheriff. If within 5 days after the taking of the property by the sheriff, the adverse party does not object to the sufficiency of the bond, or of the surety or sureties thereon, or if the adverse party so objects, and the court affirms its approval of the applicant's bond or approves a new bond, or if the adverse party requires the return of the property, but his bond is objected to and found insufficient, and he does not forthwith file an approved bond, the property shall be delivered to the applicant. If for any reason the property is not delivered to the applicant, the sheriff must return it to the adverse party. Section 7. Proceedings where property claimed by third person. If the property taken is claimed by any person other than the party against whom the writ of replevin had been issued or his agent, and such person makes an affidavit of his title thereon or thereto, or right to the possessions thereof, stating the grounds therefore, and serves such affidavit upon the sheriff while the latter has possession of the property, and a copy thereof upon the applicant, the sheriff shall not be bound to keep the property under replevin or deliver it to the applicant unless the applicant or his agent, on demand of said sheriff, shall file a bond approved by the court to indemnify the third party claimant in a sum not less than the value of the property under replevin, as provided in section 2 hereof. In case of disagreement as to such value, the court shall determine the same. No claim for damages for the taking or keeping of the property may be enforced against the bond unless the action therefore is filed within 120 days from the date of the filing of the bond. The sheriff shall not be liable for damages for the taking or keeping of such property to any third-party claimant if such bond shall be filed. Nothing herein contained shall prevent such claimant or any third person from vindicating his claim to the property or prevent the applicant from claiming damages against a third-party claimant who filed a frivolous or plainly spurious claim in the same or a separate action. Where the writ of replevin is issued in favor of the Republic of the Philippines or any officer duly representing it, the filing of such bond shall not be required. And in case the sheriff is sued for damages as a result of the replevin, B shall be represented by the Solicitor General, and if held liable therefore, the actual damages adjudged by the court shall be paid by the national treasurer out of the funds to be appropriated for the purpose. Section 8. Return of papers. The sheriff must file the order with his proceedings endorsed thereon with the court within 10 days after taking the property mentioned therein. Section 9. Judgment. After trial of the issues, the court shall determine who has the right of possession to and the value of the property, and shall render judgment in the alternative for the delivery thereof to the party entitled to the same, as or for its value in case delivery cannot be made, and also for such damages as either party may prove with cause. Section 10. Judgment to include recovery against sureties. The amount, if any, to be awarded to any party upon any bond filed in accordance with the provisions of this rule shall be claimed, ascertained, and granted under the same procedure as prescribed in Section 20 of Rule 57. Rule 61. Support Pendente Lite. Section 1. Application. At the commencement of the proper action or proceeding, or at any time prior to the judgment or final order. A verified application for support pendente lite may be filed by any party stating the grounds for the claim and the financial condition of both parties and accompanied by affidavits, depositions, or other authentic document in support thereof. Section 2. Comment. A copy of the application and all supporting documents shall be served upon the adverse party, who shall have 5 days to comment thereon unless a different period is fixed by the court upon his motion. The comments shall be verified and shall be accompanied by affidavits, depositions, or other authentic documents in support thereof. Section 3. Hearing. After the comment is filed or after the expiration of the period for its filing, the application shall be set for hearing not more than 3 days thereafter. The facts in issue shall be proved in the same manner as provided for evidence on motions. Section 4. Order. The court shall determine provisionally the pertinent facts and shall render such orders as justice and equity may require, having due regard to the probable outcome of the case and such other circumstances as may aid in proper resolution of the question involved. If the application is granted, the court shall fix the amount of money to be provisionally paid or such other forms of support as should be provided, taking into account the necessities of the applicant and the resources or means of the adverse party, and the terms of payment or mode of providing support. If the application is denied, the principal case shall be tried and decided as early as possible. Section 5. Enforcement of order. If the adverse party fails to comply with an order granting support pendente lite, the court shall motu proprio or upon motion issue an order of execution against him without prejudice to his liability for contempt. When the person ordered to give support pendente lite refuses or fails to do so, any third person who furnished that support to the applicant may, after due notice and hearing in the same case, obtain a writ of execution to enforce his right of reimbursement against the person ordered to provide such support. Section 6. Support in criminal cases. The criminal action where the civil liability includes support for the offspring as a consequences of the crime and the civil aspect thereof has not been waived, reserved, or instituted prior to its filing. The accused may be ordered to provide support pendente lite to the child born to the offended party allegedly because of the crime. The application, therefore, may be filed successively by the offended party, her parents, grandparents, or guardian, and the state in the corresponding criminal case during its pendency, in accordance with the procedure established under this rule. Section 7. Restitution. When the judgment or final order of the court finds that the person who has been providing support pendente lite is not liable therefore, it shall order the recipient thereof to return to the former the amounts already paid with legal interest from the dates of actual payment, without prejudice to the right of the recipient to obtain and reimbursement in a separate action from the person legally obliged to give the support. Should the recipient fail to reimburse said amounts, the person who provided the same may likewise seek reimbursement thereof in a separate action from the person legally obliged to give such support.